If you're doing business in Florida, 2025 marks a turning point in how civil lawsuits are handled. The Florida rules of civil procedure have undergone substantial changes, aligning more closely with the federal rules of civil procedure. These updates aim to streamline litigation, enhance transparency, and speed up resolutions. If you're a business owner or legal professional, these changes are likely to impact how you approach litigation in Florida. Let's break it all down. One of the most notable changes is the increased emphasis on early case management. Rule 1.200 now mandates that courts schedule a case management conference earlier in the litigation process. Similar to Federal Rule 16, this provision ensures that judges actively oversee case progressions from the outset. At these conferences, the court will set deadlines for pleadings, discovery, and even motions. For businesses, this means tighter timelines and a greater need to have your legal team prepared from day one. This shift aligns with the federal system's goal of reducing delays and encouraging early resolution. The Florida courts are signaling that they want cases moving efficiently, and businesses involved in litigation should expect to see quicker paths to trial or settlement. Discovery rules are where the alignment with federal practices is most evident. Florida Rules 1.280 now incorporates proportionality into the scope of discovery, mirroring Federal Rule 26b1. Discovery must now be limited to what is proportional to the needs of the case, taking into account factors such as the importance of the issues, the amount in controversy, and the resources of the parties. For businesses, this is a game changer. If you've ever felt bogged down by overbroad and excessive discovery requests, the new rule offers a safeguard. It ensures that discovery efforts are reasonable and focused, rather than a burdensome fishing expedition. However, it also means you'll need to be precise and strategic when requesting documents or information. Rule 1.280 also emphasizes the importance of relevance in discovery. Information must be directly tied to the claims or defenses in the case, reducing the likelihood of irrelevant and tangential evidence being introduced. This aligns with Florida's approach with the federal system and ensures discovery efforts remain streamlined and purposeful. Florida is also catching up with the federal system on managing electronically stored information, or ESI. Under Rule 1.380, which tracks closely with Federal Rule 37E, courts now provide clear guidance on handling the loss of ESI. If a party fails to preserve electronic evidence that should have been maintained, the court can impose sanctions, ranging from evidentiary exclusions to case dismissal, depending on the severity of the failure and the intent behind it. For businesses, this highlights the critical importance of maintaining robust data retention policies. Emails, text messages, and even social media content are now fair game in litigation. If your company isn't prepared to handle e-discovery requests, you can face significant legal and financial consequences. Additionally, Rule 1.340 clarifies how interrogatories and production requests should address ESI. Businesses need to work closely with their legal teams to ensure electronically stored records are not only preserved, but easily accessible for litigation purposes. Florida has also introduced stronger sanctions for failing to meet discovery obligations, aligning with Federal Rule 37. Rule 1.380 now gives courts the authority to penalize parties that fail to comply with discovery orders, including monetary sanctions, evidentiary exclusions, and even default judgments in extreme cases. This is a stark warning for businesses involved in litigation. Non-compliance with discovery deadlines or rules can now have immediate and severe consequences. That's why it's critical to work with experienced legal counsel who can ensure your business meets all procedural requirements. Another federal-inspired update is the inclusion of mandatory initial disclosure under Rule 1.280A. Similar to Federal Rule 26A1, parties must now provide certain categories of information early in the case without waiting for formal discovery requests. These include names and contact information of individuals likely to have discoverable information, a copy or a description of all relevant documents, ESI, or tangible items in the party's possession, a computation of damages claimed, copies of insurance agreements that may apply to satisfy any part of a judgment. For businesses, this means you'll need to be proactive in identifying and organizing relevant evidence as soon as litigation is initiated. Waiting until discovery starts to prepare can put you in a serious disadvantage. Florida's updated rules also emphasize the importance of proportionality in case management echoing the federal court's approach. Rule 1.201 creates an expedited track for complex litigation, allowing cases to proceed more efficiently. This provision is particularly beneficial for businesses involved in high-stakes disputes such as contract breaches or intellectual property claims, where quick resolutions are critical. Lastly, the updated rules reflect Florida's push towards alternative dispute resolution, or ADR, including mediation and arbitration. Courts are strongly encouraging parties to resolve disputes outside the courtroom when possible, reducing the burden on the judiciary and creating opportunities for faster and less expensive resolutions. Rule 1.700 specifically addresses mediation procedures and deadlines, requiring parties to engage in ADR at specific stages of litigation. For businesses, this creates opportunities to settle disputes on more favorable terms, but it also demands careful preparation. Mediation and arbitration require a clear understanding of your case's strengths and weaknesses, as well as skilled negotiation. The 2025 updates to the Florida Rules of Civil Procedure are a significant step towards modernizing the state's litigation process. By aligning with federal standards on discovery, proportionality, and case management, Florida courts are signaling a commitment to efficiency, fairness, and transparency. For businesses, these changes underscore the importance of being prepared and proactive. Litigation timelines will be tighter, discovery requirements more exacting, and compliance expectations higher. Working with experienced legal counsel is now more critical than ever to ensure your business navigates these changes effectively. At our law firm, we specialize in helping businesses adapt to regulatory shifts like these. Whether you're revising your contracts, implementing data retention policies, or preparing for litigation, we're here to guide you. The updated rules may be complex, but with the right support, they can also be an opportunity to strengthen your legal strategy and protect your business.